I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me. And then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep, if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox, so.
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as.
I honestly think the judge is just fed up with Lori Vallow. He's trying really hard to be patient with her. However, with Lori Vallow just yapping away, it's really hard to be patient with someone who just goes on and keeps cutting you off and honestly doesn't know what the hell they're talking about. So Lori Vallow was getting quite unhinged today in today's hearing. Now, she has a trial coming up soon in 2 weeks, which we are planning to be live streaming. This is for the attempted murder of Brandon Boudreaux, her niece, Melanie Boudreaux's husband at the time. Yeah, we got like a family tree here, similar to like the whole like Canton police and the Albers and all that stuff here. So I hope you guys are all following along. By the way, Lori Vallow is going to be deep throating her microphone. Okay, I don't know why she's like all up in the microphone, but just bear with me. Whenever she starts talking, the microphone is going to be really bad. So what needs to take that microphone and just back it away just a little bit.
I received the response. I think the reply is due today. Is that being filed?
Yes, Your Honor, I have it right here. And
is it ready to be filed?
yes,
Okay, we'll file that. You have a copy for the state?
I do.
Okay. The response, I'll take a look, or the reply, I should say. I'll take a look at that.
Do you think this is a trial? This trial is a way to get any other family members indicated, like the niece or her mother? I mean, she could have tried to call more witnesses in the murder of Charles Vallow, and she didn't. So I think if she wanted to try to pull something like that, maybe she would have called them when she was presenting her case. So remember, when the state rests her case, we're like hoping Lori Vallow would testify or she would call some witnesses, even though she seemed to not know what the fuck she was doing with the subpoenas. I don't know what she's doing. I don't even know if she knows what she's doing, but she seems like a very confident person.
The next thing I wanted to discuss was the state had filed a notice of its intent to use defendants' other acts to establish conspiracy, premeditation, and/or establish motive pursuant to Rule 404B. In your pretrial statement, you indicated you wish to strike or withdraw that?
Correct, Your Honor.
Okay, so that's withdrawn. Next, we have state's request to preclude the media from showing the face of a testifying witness, one of the witnesses. I'm assuming you don't really have a dog in that fight, Ms. Daybell? Or do you have a response?
I don't have a dog in the fight, but I haven't had a chance to read over. I just got a bunch of this stuff, so
Did you really just get a bunch of this stuff, or have you had it for a little bit and you just didn't really read it? I don't know if I really believe Lori anymore, because Lori has made some accusations at the state. For example, do you remember mid-trial, there was a time where I think Lori Vallow is like investigator or someone like that on her team, had issues with opening some sort of like Cellbrite file, something like that. And Lori Vallow tried to say that like, oh, the state dumped like all this like cell phone evidence mid-trial. But then when we looked at the state's response, the state was like, no, she's had it for about like, I think a year now or something like that. They just didn't really get into it. So when Lori Vallow says things like, oh, I just got it, I don't know if I believe her, because Lori Vallow is, she's not trustworthy, she's not trustworthy.
I'm not really sure what they're asking for.
Well, one of the witnesses also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that witness is doing. So it's a request to not broadcast his face through the media out into the...
I don't have the motion on me because it was on a Facebook post, and I usually don't like showing Facebook on streams. But now, I think the agent that you're talking about is Agent Nicholas Balance. And if that name rings a bell, then you guys might be following the Idaho 4 murders case as well. I think it's the same agent. Nicholas Balance was also an agent, same name, on the Koberger case. And remember, they were doing the cell site tower analyzation thing. And then Koberger's defense expert was saying that, like, oh, this guy, like, we don't know how he put his data together. There might be some evidence that he precluded that could be exculpatory to Brian Koberger. And there's like a whole like shitstorm. And basically, yeah, I think it's the same guy. Because the same name, Nicholas Balance, works at FBI, does like the CAST system and the cell stuff. So I think it's the same agent. And I was really excited to possibly hear this guy's testimony because remember the defense threw some accusations at Nicholas Balance. And now I kind of want to know, are we going to find this guy credible? And, we could see him testifying in this trial just to get like a feel for him. So when I read the motion for this case for Lori Vallows, apparently this FBI agent is going to testify about, maybe like cell site locations of some of the victims or maybe like some of the people involved in this case. However, because they might be involved in some undercover work for the FBI, they don't want to broadcast their face to the entire world. So that's what they're talking about with this motion. And then they're like, hey, the state wants to make sure that this person's not going to have his like face live stream. Lori Vallow, are you okay with that? And Lori's like, I don't know. I just got it. I don't know what's going on here. I don't know. I have no dog in this case.
Public. It also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that witness is doing. So it's a request to not broadcast his face through the media out into the public.
And is this witness FBI or something to that effect?
It's Nicholas Balance. I think he is an FBI agent.
Correct, he is an FBI agent.
And he's a relevant witness because of why?
According to the state's notice, he created a PowerPoint regarding some of the Wi-Fi or cellular data
Cellular
location.
and Wi-Fi use, yes.
Yeah.
I have no real objection to him being obscured. I don't know how they'll do it, but
All right, so I'll direct the media during trial when witness Nicholas Balance
We'll just throw a paper bag over his face. It'll be fine.
is called to testify. They can't broadcast his face out. They can focus the lower part of the witness stand or something like that, but his likeness or image or face should not be broadcast out to the public. So I'm essentially granting the state's request in that regard. Next, we have state's amended request.
Ooh, I like Trina K's privacy monitor. You see that? You don't see anything on her screen. You see that little chrome reflection.
In that regard. Next, we have state's amended request for Rule 609 hearing and the defendant's response. When I read the amended request, you're simply adding the most recent conviction, correct?
Yeah.
You didn't really respond to that in your reply. You kind of just talked about the previous reply that you had made about, did you notice that she had asked to basically add your most recent conviction?
AKA the judge is saying, so Lori, it seems like you didn't know what the fuck you were doing. Did you just not see it? Like what happened here, ma'am?
saw that, but I didn't know what the law was since I wasn't sentenced for that yet, so I wasn't quite sure where to go on that, so I left it off.
Okay, with the 609, I think similar to the last trial, I'll put that off, and depending on if you testify or not, it only really becomes relevant if you decide to testify. So we'll table that for the time being.
Let's see. 609, Arizona. Oh, Rule 609, impeachment by evidence of a criminal conviction.
Next, I have the state's motion limiting to preclude inadmissible evidence relating to Tammy Latchik, who is a evidence scene technician type person from the, I think it's city of Chandler.
Gilbert.
Did you, or I'm sorry, Gilbert. Did you have a chance to review that?
I just got it, and I am in the middle of responding to that. But I do have a request in that regard
Which is?
from the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now, we need additional information, and due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident and any recordings or body cam videos so that we don't have to have my investigator try to do an investigation so quickly. If they have that information, if it could be turned over to the defense so that we don't have to try to gather that information so quickly.
Well, I don't think you're necessarily entitled to all those things if
I think I saw a glimpse of her makeup. Is that pink I see there? She got a little bit of pink there?
it's deemed that incident is irrelevant to her testimony. So I think the threshold issue is if you want to file a response where you think that is relevant, something that you can get into, an incident that happened 4 years later, I guess when can you file your response?
Without any further information, I don't know when is that response necessarily due, Your Honor.
It was filed May 3rd, so technically it's already past due. So can you file it by next, you have a copy of it now,
I just got a copy, correct.
right? How about next Wednesday, the 21st?
Yes, I can do that.
All right, so we'll
And
set
I have
that
a
aside.
Wait, it was filed May 3rd, but she just got a copy? Just got a copy?
Question on that. Yes, I can do that.
All right, so we'll set
And I have
that
a
aside.
question on that as well. Can I make an objection on the sealing? Can I ask under what law or rule or statute that this motion was sealed under?
They've requested to file it under seal because of the nature of the motion and the contents of what that incident is, not needing to necessarily be in the public eye. So if you want to include in your motion an objection to it being filed under seal, you can do that as well.
Okay,
So you'll file that no later than May 21st. I don't need a reply on that. I'll deal with that, I guess, probably our first day of trial or so.
so you're not going to set a 609 hearing?
This is not a,
Oh, not the 609, but a hearing for Tammy Lachik?
I can listen to oral argument when you filed your reply, but I don't believe I needed any sort of hearing on it. So I'll deal with that May 29th or 30th, I suppose.
I mean, I get it. You know, you're pro se. It probably takes a bit. There's a delay because you're being incarcerated, get documents over to you. But damn, like 6 weeks to get the documents over? Maybe something happened.
All right, then we have the defendant's motion for no restraints in trial dated May 6th.
Oh, yeah, no restraints. So during trial, we found out, I think like midway, that she had the belt thing. Essentially, if she were to try to do something, escape, or maybe attack someone, they would have the little shocker and she'll just get like jolted really quickly in the stomach area. She didn't have the shock shackles, but she had the belly shackles, I guess.
I don't know,
Belly
in your
shock shackles.
motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum
Why would they ever recommend, yeah, just let her raw dog it. She don't need a restraints or anything like that. Yeah, right, sheriff's office.
recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here and I copied it verbatim.
Yeah, you
Okay,
said, what it
recommendation.
said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation.
Response, Lori?
I've received, the defendant's motion, I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph V. Hill for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket.
Did y'all see that? A strap hanging down? I don't know if I saw that. I probably wasn't paying attention. I was probably too blinded by her stupidity. No, okay, let me not be too mean.
We did that. We rectified the
myself.
situation. There's been no indication whatsoever that the jury noticed the rack bell or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right? There was no request for that.
Oh gosh.
All right.
So the judge, I love it how like the judge is like so like over her. When what I noticed during the trial was whenever he made a ruling or if he had to address her, he would kind of just like look through her. Not really make eye contact with her. Oh man, and similar to right now, you know, he's like, "Yep, and you didn't poll for it. Yep, you didn't request for it. Whose fault is that? Who's representing themselves?"
So next we have
Oh, Lori. Who's she smiling at over there?
defendant's motion
Lori is like, "It's not me. I'm not the one who's incompetent. It's these people. They're just against me. They're biased against me."
to consult with advisory council and team during trial dated May 6th. I don't know, I guess, what exactly are you requesting? Are you requesting that during the lunch recesses, you be housed somewhere where you can meet with your team?
Correct.
Okay.
And I know that it's a, you know, it's a DO situation, and I know that our DO has his other obligations to do, so I didn't know if another officer could maybe, if something could be arranged so that I would have time with my team during those breaks and during lunchtime.
Hey, Muhair, how are you doing today? Hi, Corky. This is a good break from Karen Reed and Diddy Trials. Yo, in my Discord, we were just wondering what the fuck is up with the Diddy sketches. Even my brother, who doesn't follow true crime stuff, like DM'd me and was like, "What's up with this Diddy sketch?" I'm like, "Bro, I have no idea, but these sketches are fucking hilarious." And then for the Karen Reed stuff, yeah, I got up to the Karen Reed up to the lunch break, and then when I was getting ready, I was like, "Oh yeah, I forgot Lori Vallow got her pretrial stuff today."
We did accommodate that during breaks and recesses during the trial, to the extent that it doesn't delay the jury getting into the courtroom and resuming the trial when we need to, like when we take the 15-minute afternoon recess. That will continue. You'll have an opportunity to meet with them briefly. Over the lunch hour, I think is the real question. I did receive a response this morning from the sheriff's office, which indicates they don't really have an objection to that. Is that correct?
That's correct, Your Honor. There is an area on the fourth floor in the South Court Tower where she can be taken to meet with her advisory council, and they'll work that out.
All right. I don't have a problem with that. So if you need to meet with them when we break for lunch, just indicate to the DO that's what you need to do. There may be a day where you don't need to meet with them, but I'll essentially grant. Ms. Kay, I don't assume you have an issue with that.
I have no position on it.
So I'll grant the defendant's motion on that she can meet during the lunch hour. Again, the only restriction on that is that we're not going to delay bringing in the jury at 1:30. We'll expect everyone back in the courtroom to start on time. All right, let's talk about the trial schedule and the screening.
Ooh, yes. Okay, let's talk about the trial stuff really quickly. This is what I got yesterday from the Twitter. Shout out to Justin Love. Here's what we got. Or actually, maybe I should show that in the next portion. Actually, no, I'll let the judge talk. They'll probably talk about it, and then we'll get to it next portion.
I received in the state's pretrial statement. Have you seen that?
I just did, yes.
Your Honor, may I be
Yes,
excused?
go ahead. Thank you. The state's pretrial statement indicate there was some witness scheduling issues. If we get the jury sat on the 30th and impaneled on the 30th, the last Friday in May, and we have our opening statements and begin testimony and evidence Monday, June 2nd.
Wow, in 2 weeks.
You indicated that, the state indicated you would run out of witnesses either Wednesday or sometime Thursday.
Correct. That are available that week, yes.
Right, and then so we'll definitely go dark on Friday the 6th. I had initially indicated we would be in trial on that day, but if we
Yay, we'll have Friday off.
can't have any witnesses here, we'll be dark on that day, and we'll indicate that for screening purposes for the jurors. I
So
think,
there's some witnesses that can't testify that week, but they can testify the week afterwards. And then one of the witnesses, like that I mentioned earlier, is federal agent Nicholas Balance, who I look forward to hearing their testimony because I believe it's the same person who's also going to be testifying in the Koberger case.
we'll still indicate that we'll be in trial on the 5th, and we'll have to play that by ear. Maybe we will be dark, maybe we won't. But as far as when you resume on the 9th, you said you thought you would have 3 witnesses left at that point?
Correct.
Do you have an anticipation? Are those witnesses that would each take a whole day, or?
I think it's possible I could finish that day.
So ultimately what I'm getting at is trying to drill down the schedule and screening for the jury. Do we not need to screen them for the week of the 23rd?
Obviously, I just received the defendant's 15.2 that lists 2 different expert witnesses. I did request that they actually comply with Rule 15.2 and give me any information about any of these experts. They've also listed other witnesses. So because of that, I would still screen them for the other week.
Well, maybe we should address that. Is there still no report from Lonnie Dworkin that the state's received?
I have received nothing.
Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Well, when is that going to be? Because it's way past due.
So the state
Hi, Diane. How are you doing today? Oh, man. Just like, the judge is like throwing a little bit of snark here and there, but it's not like unjustified snark. It's like, all right, so when are we going to get it? Because it's way past due, Lori. What's Lori going to say to this?
Past due.
So the state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. He's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
Not really an answer. Just as soon as possible. As soon as possible. I think the judge wants a date.
All right, well, it's depending on what's in that report, it is likely to be precluded at this point, but I'll keep an open mind on that, and it's
too
We'll
late.
wait and see. Let's talk about.
And who knows if it's even going to be relevant or not. Lori Vallow had issues with relevancy last trial as well. And she was like, it's relevant, Your Honor. It's relevant. Judge is like, okay, well, tell me why it's relevant. Well, it's relevant because it's relevant.
For the purposes of scheduling,
Your Honor, and just, there's one other person that I'm Googled.
I'm going to ask her about the other
Okay.
witnesses. I received your supplemental witness list, I think yesterday. You have, in addition to Mr. Dworkin, you have Weaver, Barkman, again, Detective Moffett, Jeffrey White, Melanie Gibb, and
Oh, Melanie Gibb. I want to hear from Melanie Gibb. I don't think we've ever heard from Melanie Gibb before in any of the trials, have we? So Melanie Gibb is her niece, and apparently she was kind of like in the cult as well, maybe not as deeply involved as Lori Vallow, but I think she was like kind of like sort of involved. Now, remember, there was text messages between Lori Vallow and Melanie Gibb, and essentially Lori wanted to make sure that Melanie was around just in case they would have tried to ambush her and do a intervention.
and Zulema Pastañas.
And Zulema, I think it's pronounced Zulema. That's her brother or deceased brother's, I think, ex-wife. But they were married at the time. So Alexis Cox's wife. So it'd be interesting to hear from Melanie Gibbs and Zulema, because again, Melanie Gibbs' husband was the one where the attempted murder was on.
Zulema Pastañas.
Okay. Was Detective Moffett also involved in this case?
Oh, Melanie Gibb is the friend? Are there 2 Melanies? Am I getting it mixed up? Oh, hold on. Because Melanie Boudreau, sorry, I just assumed the Gibb was her maiden name, but then her maiden name would probably, because she was on which side? Melanie Gibb, mom's side. Oh, is Melanie Gibb the friend? I'm getting mixed up. Thank you. Hold on. Melanie Gibb. I'm going to do what Trina K did, and I'm just going to Google it. It seems like Trina K didn't know who some of these witnesses were. She's like, yeah, I Googled some of them. Lori Vallow. Let's see. Oh, that's Melanie Gibb. Okay, she's given interviews before. Lori Vallow Daybill's former best friend. Thank you, thank you, thank you. Okay. Thank you. Pawlowski. Okay. Pawlowski. Melanie Pawlowski. Oh, okay. I had it mixed up. I thought Melanie Gibb was the I thought Gibb was her maiden name or something. Thank you, Muhair. Thanks, Sharon. I appreciate it. All right, guys. Erase what I said earlier about the Melanie. This is a different Melanie. This is Melanie Gibb, a former friend of, or former best friend of Lori Vallow.
He was involved with the case agent of this case while he was the case agent of the other case. Correct.
Oh, okay. So I think he wants to ask Lori Vallow why some of these witnesses are relevant, and this is where we get into the funky relevant answers from Lori Vallow. So Detective Moffat, I believe, testified in the other trial with Charles Vallow. Lori wants to call Detective Moffat again, and the judge is like, "Is he involved in this case? Why are you calling him?"
It's Dennis.
Okay. Was Detective Moffat also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case. Correct.
Okay. So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert.
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
Not yet, Your Honor.
Are we surprised? Are we surprised? 2 weeks before trial? Are we surprised?
We're working on it.
Your Honor, since I have not noticed a ballistics expert, that's a big problem, because if I get something, then I would have to do that. So the defendant's, again, extremely late violation of all rules of criminal procedure is a problem.
It is a problem. Who's Jeffrey White?
My investigator.
Oh, okay. And do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two
We were going to have him inspect that as well, meaning he hasn't even done it yet. I thought maybe he did it and the report just hasn't been generated yet.
things do not exist. So I'm not sure what they're going to be putting up as far as ballistics in their case in chief. So I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. What's Mr. White's relevant information for, why might he be called as into trial?
Because he's interviewing the witnesses as well, the defense witnesses.
So is it some sort of extrinsic impeachment if they,
Correct.
Yeah, she's like, correct. It's like, girl, you didn't know the answer to that question. The judge was just helping you out here. He was throwing you a bone.
what about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but they have relevant information to this case.
Have they been presented for an interview by the state?
They've both been interviewed multiple times by the state.
I mean, not by police officers, I mean by either a prosecutor or someone in her office in preparation for trial.
Any depositions, anything like that?
In this case,
Yeah, in either case,
not that I'm aware of.
have they been subpoenaed?
The subpoenas are out.
Lori's not flirting today because she knows it doesn't work with this judge. Kelsey, I said earlier that she's going to be deep throwing that fucking microphone.
What relevant information would they have?
They have relevant information to Brandon Boudreaux?
Okay.
I do feel bad though, because in trials or in hearings like this, I do wish there was a way for the person that's speaking to the microphone to hear how it feeds back in. Especially when there are witnesses that are testifying on the stand and they don't realize they're too close to it and they start breathing really hard into the microphone. All
And around that
What
time?
is the nature of that relevant information?
right, let me go back a little bit. So we're trying to figure out, why are these people relevant?
Not that I'm aware of.
Have they been subpoenaed?
The subpoenas are out.
What relevant information would they have?
They have relevant information to Brandon Boudreaux.
Okay.
And around that
What
time?
is the nature of that relevant information?
Choose another answer.
It will come apparent if they have to get up and testify, Your Honor. I will only call them if I need
Well, they're going to
them.
be precluded if you can't give me some minimal, what relevant information they have. Just saying that they're relevant doesn't make them relevant. Okay?
Yes, and is this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state? It is?
Yeah, it's
That's
just
how
like-
it works?
like
That's
the-
the rules of law?
Stop interrupting me. Yes, that is the rule of law. That's just what the state does. They tell you what relevant information each witness has. So,
Went to law school versus didn't go to law school. Law school? No law school. Experience? No experience. Smart judge? Moron. I'm
My
being mean
answer's
today.
yes.
Oh, I'm going to tone it down.
so if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact with Mr. Boudreaux or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
I was saving Rain's comment for this. Rain says they are relevant because they've eaten her green chili chicken enchiladas. True.
Or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and they're saying they're not relevant?
Apparently not. Are you calling them?
No, they're not on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies in if I have to rebut something that the state puts on in their case in chief. They're just called in case they need them. They're subpoenaed in case I need them.
All right. It sounds like they don't have relevant information. However, I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses out of an abundance of caution. That's really
When you get a non-answer, you got to answer it yourself and just move on. That's what the judge is doing.
the purposes for today is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses. But I'll include them on the witness list. I think what I'm hearing is you said you might finish on the 9th or the 10th? I'm going to indicate on the questionnaire to the jurors, potential jurors, that the trial is likely to end by June 13th, Friday, June 13th. However, I'll include
Yay, short trial. Remember how the other trial they estimated to be 6 to 7 weeks because Lori Vallow barely did any cross-examination or even displayed any witnesses herself. It was just like, what was it, like 1 week, 10 days or something like that?
That Monday, the 23rd, and kind of say, if needed or if required, might go to June 23rd out of an abundance of caution.
Yeah, and spending your summertime in a courtroom.
So I'll finalize that questionnaire. It's pretty much done, and it's pretty much the same as the last one, except for the names of the witnesses, the specific allegations, and then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case. But I'll send you guys out a copy. Actually, I could probably finish it in the next couple minutes and print out a copy so you have it before you leave here today. That questionnaire, I need to get with the jury office. I think we were talking about sending it out the 22nd and cutting it off the 28th or 27th. And then we'll meet again on the 29th in this courtroom to go over the responses. That'll be at 1 p.m. on the 29th.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
I was a little curious about this. I was like, oh, her personal life stuff, like in the jury questionnaire, what were they including? This definitely intrigued me.
What personal information?
The state versus Lori Daybell.
That's the name of the case.
That's why I was like, I can't take Lori serious anymore. I just can't take her seriously. I was like, oh my God, they included her personal information. Like, what was in it? That sounds kind of weird. Well, my name was on there. The state versus Lori Daybell.
You don't put that on anyone else's questionnaire or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name?
She can't answer. Look at the judge's face. Okay, hold on a second. I need another. We did this for the trial. Do we have one here? I think we need like a zoom in for the judge, man. You gotta see the judge's face. And the judge is like, I'm waiting for an answer, ma'am. Give me an answer. Oh my gosh, poor judge. Don't worry, judge. You just have just a couple more weeks of this, and you know, there'll be some appeal stuff that you might have to deal with, but you know, you'll be done with Lori soon. You'll be done soon.
Done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name? Do you have a response to that?
I'm just saying, you gave them your name, and they're just going to Google it.
They're instructed not to Google it, all right? And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that.
That's true. Your Honor, if they Google me, they'll find about the loin fire.
If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
I can't wait until we get the sidebars for the trials. The sidebars between Lori and the judge, we need to get the sidebars. Oh my goodness. If y'all thought the Sarah Boone's, oh shit. I forgot to post part 3 of the Sarah Boone sidebars. Oh, I'll post it today or later on today. But I want to read the sidebars between Lori Vallow and the judge. Oh my gosh.
No, Your Honor.
She gets so frustrated, but it's not like she even gave a good argument. Why are you getting frustrated? Your argument isn't good. You should know yours isn't good. I don't know. Maybe she doesn't know that her argument isn't good. Maybe she really thinks that she really has something here and that she was arguing, wholeheartedly. But most of the time when they're arguing, where she's arguing with the judge back and forth, a lot of it's just like silence, or she just repeats herself, or she just goes in circles. And then you get frustrated that you are losing these arguments, but you're not getting frustrated yourself. She's probably getting frustrated at other people, blaming other people.
So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive are screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury at some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right?
You know what? It's not because I'm not making good arguments. It's got to be personal bias. It's got to be other things. It's not me. It's them.
I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that, all right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit?
Hold her to that. Hold her to that. Every single one of her motions has been denied. That's her claim. Well, hold her. We'll have her the argument.
Denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour.
Ooh, Lori, you just got destroyed. Lori, you just said every single motion. They're just like, well, what about the one this morning? I just granted your motion. Let's see if Lori responds to that.
Does not have merit. You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted.
Well,
Oh, but you just said that he hasn't granted any motions the past year and a half.
On my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit.
Not
No, I guess they're just garbage, Lori. I'm sorry. I guess it's just, maybe you should just hire an attorney or something.
many, no.
And none of the motions that my first team, you denied every one of my first team's motions. You denied every one of my second team's motions. And now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any,
He's like, hey, I understand. You don't know what you're doing. And that's why you don't understand the process. That's why you don't understand the results. Oh no, Chad would never deny my emotions.
I've ruled on the motions as required by law.
without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
You're telling me the judge has never said a case law? He just denies it. He just outright denies it. I'm sorry, but Lori, you've already shown yourself as someone that exaggerates just to try to prove your point, and it ends up becoming moot because when your point is not proven and it actually becomes disproven, she just moves on and moves the goalposts. Okay, fine. Well, you granted that one motion. Okay, fine. You might have granted that one. Okay, well, you haven't granted any other ones.
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else? All right, I was handed a
Quiet.
motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did
Jeep
you probably
Wrangler?
got a copy of it today or not?
Oh, is this the car that Brandon Boudreaux was driving or coming out of when he was shot at? I thought it was in a Prius for some reason.
No.
Oh, do we need to make copies?
Thought I heard Prius. Maybe not.
All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence. So make a copy. I guess the state can file their response to those.
You got a jury duty that would have been a 30-week trial. Kind of want to be picked because your work pays for jury duty. That's fucking awesome that they pay for jury duty. That's cool.
All right, anything else for today from the state's perspective,
No, Your Honor.
from the defense?
No, Your Honor.
All right, we'll see everyone on the 29th at 1 p.m. Again, that's in this courtroom.
Oh, here's a smiling Lori. Nothing phases her.
Yeah. Thank you.
Oh gosh, Lori, 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 Lori. That chipper attitude is no more. Okay, we got more Lori stuff to cover. So for the Lori Vallow pretrial hearing, that was for the attempted murder on Brandon Boudreaux. Apparently he's going to be testifying, and yes, he is still alive. Yay! Unlike Lori Vallow's other victims, unfortunately. So they're going to have their trial in about 2 weeks. The trial is going to be roughly, I don't know, like 7 to 10 days long. And then possibly it might go into June 24th, depending on who knows what. We'll see what, maybe Lori's performance will be better this time around. Maybe she's learned. No, I don't think so. Because after that, just now, like Lori, I don't know why she's still representing herself. So here's a little breakdown of the Lori Vallow's trial that's coming up soon. Charges, we just one charge. Count 1, conspiracy to commit first-degree murder, life with a possibility of release after 25 years, although that won't really affect Lori Vallow at all. Settlement status, no offer has been made. Again, they're going to have 12 jurors plus 4 alternates. Here are the lists of the state's witnesses. We got people from the Gilbert Police Department. I don't recognize them. Chandler Police Department, Mesa Police Department, Phoenix Police Department, Department of Public Safety. We've got Rexburg Police Department, FBI. This is the name that I recognize, Nicholas Balance, although I think there's an L that's missing. If you guys are familiar with the Idaho 4 murder trials, Idaho 4 murders, that one has an expert with the same exact name who did the CAS system stuff and the analyzation of it. So I think it might be the same guy. It'd be interesting to hear his testimony in this case, because the issue with the other case is that they're trying to say that the people that worked on kind of pinpointing Kohberger's location the night before the night of the murder, but like hours before the murders, during and afterwards, there was some information that could have been omitted, that could have been exculpatory to Brian Kohberger. So I do want to hear Nicholas Balance's testimony to see if he sounds like he might be a credible witness. We have DEA, we got civilians. I don't recognize a lot of these names, but maybe you guys do if you guys are familiar with this case. We have a Robert Anthony Abato Marco, Brandon Boudreau, who is the victim, Elizabeth Jane Collins, Timothy Zane Deloach, Lynette Mendoza, and Dan Moss. I only recognize Brandon Boudreau. Estimated trial day, 7 to 10 days. Here's a brief statement of the case to be read to the jury. The state alleges that in the days leading up to and including October 2nd, 2019, so at this point, Charles Vallow was already murdered. I believe Tylee and JJ were also already murdered, and same thing with Tammy Daybell as well. Charles Vallow, again, was in July, and then I believe JJ and Tylee, do you guys remember? Was it in September, I think, right? September, possibly? Maybe about 2 weeks apart. Lori Vallow Daybell and her brother, Alexander Cox, conspired to commit first-degree murder of Brandon Boudreau. The state further alleges that Lori Vallow's co-conspirator, Alex Cox, drove a Jeep. Oh, the Jeep belonged to Lori. Got it. Okay. The Jeep belonged to Lori Vallow, but Alex Cox drove it from Rexburg, Idaho, to Gilbert, Arizona. The state alleges that on the morning of October 2nd, 2019, Alex Cox shot at Brandon Boudreau from the Jeep as Brandon was returning to his house at 3875 East Fells Street in Gilbert, Arizona. Brandon Boudreau was not injured. Trial schedule. The state has identified approximately 22 witnesses for this trial. 5 of these witnesses reside outside of Arizona. State has learned that 3 of the witnesses are not available to meet the week of the June 2nd to June 6th, 2025. Witnesses Timothy Deloach, Timothy Miller, Nicholas Ballens are not available to testify until Monday, June 9, 2025. The state believes that the case in chief will take approximately 4 to 5 days. The state believes that it will conclude with all the available witnesses either Wednesday, June 4th, or Thursday, June 5th. Yeah, the trial of Charles Vallow, the trial for Charles Vallow went by pretty quickly. They're just like boom, 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 get to the point. I freaking loved it. I like that speed. For these reasons, the state asked the court to go dark on Friday, June 6th, and potentially Thursday, June 5th. So these might be our days off. Resume on June 9th to call the remaining 3 state witnesses. Pending motions. Defendant's motion dismissed for abuse of discretion by Judge Boreski. That's Lori Vallow. State's amended 609 motion. State's motion in limine to preclude inadmissible evidence relating to Tammy they pronounced it earlier in court, but I don't remember it. Lachick. The state's request to preclude the media from showing the face of testifying witnesses. So that's what they addressed today in today's hearing. The state hereby moves to strike the state's notice of intent to use the defendant's other acts pursuant to Rule 404B. So that is what they covered today, and things were getting very fiery between Lori Vallow and the judge. Oh, man. So we will definitely be live streaming the trial when it happens in 2 weeks. Now, they're going to follow the same rules. It's not going to be live stream, like live. There is going to be a 30-minute delay, and you know what? I'll take that. I kind of like the 30-minute delay. And then we'll also refer to people who are going to be live tweeting from the courtroom. So Justin Lum, there was Nate Eaton, and there was another person, maybe Pretty Lies and Alibis, that was also tweeting here and there as well. So we'll take a look at their tweets, assuming if they all 3 will attend this trial. We're going to go over Lori Vallow's motion for a new trial because she's going to say jury misconduct, prosecutorial misconduct, the judge was biased, and then the state's response to that. So check it on a different video, and if you guys enjoyed today's video, hit the like button, subscribe if you haven't already, and feel free to stop by the live streams and stop by and say hello. We'll be definitely streaming this trial live. And then we've been doing Karen Reed off and on here and there, depending on what witnesses testify. So guys, thank you so much for watching. Have a good one, and I'll see you guys later. Bye.